Well, that's really my next question, because in March of 2005, after you'd left office, you wrote to Lord Goldsmith stating that in the Cabinet meeting of the 17th of March, you had attempted to initiate a discussion, but that this was not allowed. What was it that you were trying to discuss in the Cabinet on the 17th of March, and why were you not able to do so?
I had asked for that special meeting with the Attorney-General, and it had been readily agreed that it would take place. That was the first time he came to the Cabinet that I'm aware of. He sat in Robin Cook's seat, because Robin didn't come to that meeting. Again, I don't know why he didn't come and argue, but he didn't. There was a piece of paper around the table, which we normally didn't have any papers, apart from the agenda. And it was the PQ answer, which we didn't know was a PQ answer then. And he started reading it out. So everyone said, we can read, you know. We didn't. And then, everyone said, well, that's it. And I said, well, that's extraordinary. Why is it so late? Did you change your mind? And they all said, Clare, stop. I mean, everything was very fraught by then, and they didn't want me arguing. And I was kind of jeered at to be quiet. And that's what happened.
So you went quiet?
Well, I mean, if he won't answer and the Prime Minister's saying, be quiet and that's it, no discussion, there's only so much you can do. And on this, because I see the Prime Minister, and he said, the attorney, the then attorney, to be fair to him, says he was ready to answer questions, but none were put. I did ask him later, because there was then the morning war cabinet, or whatever you call it, that he did come to, and he gave all sorts of later legal advice. And I asked him privately, how come it was so late? And he said, oh, it takes me a long time to make my mind up.
I mean, the argument on this Cabinet meeting that we've heard...
I'd like to ask you to ask for the books. You know, the Cabinet Secretary keeps a manuscript note, and there's another private secretary that keeps a manuscript note on this. I think you should check the record.
We note that. The argument's been made that the Attorney-General is a senior legal officer of the government. When he actually reaches a decision on this, there's no point in the Cabinet debating it, because he has come to the firm legal view on this, and therefore there wasn't actually anything at that point to discuss. You just have to accept his authority as a law officer on this question. But you don't agree with that?
Well, I did. I was stunned by his advice, but as I've said, I thought, in the teeth of war, the Attorney-General of the United Kingdom coming to the Cabinet to give legal advice. This is a very serious, monumental thing, and that's his advice. And I'm very surprised, but we must accept it. That was my view.
Now, you've now had the benefit of seeing the earlier advice he'd given, his formal advice to the Prime Minister of the 7th of March, which is a much fuller document looking at more than one option. Do you think that it would have actually changed the Cabinet's decision if they had been given a chance to see that advice of the 7th of March?
I think people would have thought it was much more equivocal and risky and wanted to be more sure and less certain. And the other thing, I didn't know till Elizabeth Wilmhurst resigned and it was in the press, that both the Foreign Office legal advisors had said there was no legal authority. I think we should have been told that. And I also think this, because the side document, because you can tell he was uncertain, he made Blair write and sign a document saying Saddam Hussein was not cooperating under the terms of 1441 and was in material breach. When Blix was saying, do you remember he got rid of the ballistic missiles? And he said, these are not matchsticks or toothpicks or something, remember? And he was asking for more time. So at the time when Blix was asking for more time, the Prime Minister secretly signed to say there was no cooperation. And Blix was saying, I'm getting some cooperation. So, I mean, this is disgraceful.
That was because Resolution 1441 had required a determination that Iraq was in further material breach. And the argument which was made by the Foreign Office legal advisors, and still is made by Sir Michael Wood, and had been made by Lord Goldsmith until the 11th of February, was that only the Security Council could give that determination. But Lord Goldsmith subsequently came to the view, the better view as he called it, that this determination did not have to be given by the Security Council, but it still had to be given by somebody. So wasn't he then correct in going to the Prime Minister for that determination, so that as it hadn't been given by the Security Council, it had been given by a member state of the United Nations.
Well, one, I don't accept that 1441 can mean you have to come back to the Security Council for an assessment but not a decision. I just think that's a piece of nonsense, even though Jeremy Greenstock argues it, and I respect him enormously. I think that is unbelievable.
Well, there are different views on that.
Yes, I know, but I'm just saying that.
That's your view.
But secondly, and it was the view of many other countries and other lawyers, of course. And I think the very fact that the French asked for a different word and didn't get it doesn't mean that the opposite holds. But secondly, if the Attorney General is coming to us and saying this is this complex way in which I'm interpreting 1441, and therefore the Security Council can't decide whatever Blix is saying, therefore I've asked the Prime Minister to give a written assurance, I think we should have been told that. That was all kept from us. And we were just given the PQ answer that said unequivocal legal authority. No questions asked, no doubt. I think that's misleading.
Could I finally move on to a question that you did refer to earlier that I said we'd come back to? In his evidence on Friday, Mr. Blair gave the view that, and I'm going to quote here, if we'd left Saddam there with the intent to develop these weapons and the know-how and the concealment program and the sanctions had gone, today we would be facing a situation where Iraq was competing with Iran, competing on both nuclear weapons capability and competing as well in support of terrorist groups. I've left a few words out in the middle of those quotations where they simply interrupt the flow, but you can see the full quotation in the transcript. Now, that's what Mr. Blair, I think, called his 2010 question. Was it a question that we actually either had to take military action to topple Saddam in order to remove this threat, or, if we didn't do so, Iraq was going to become both a nuclear and a terrorist threat, as Mr. Blair suggested in his 2010 question?
No, I think that's, historically inaccurate. For example, well, first of all, there was what the stated policy was supposed to be, which was we can't leave Saddam Hussein there, not in compliance with the UN, and sanctions forever, they're eroding, therefore we need to take action, the argument that I agree with. But there was no evidence of any kind of an escalation of threat, so there was no hurry. I mean, that's one of the kind of untruths, the exaggeration of the risk of the WMD. So get the inspectors back in, get disarmament and compliance. If you get that, the logic is release sanctions, open up the country. Now, going on alongside that, and I'm sure that's in the public domain, were initiatives from the Saudis and the Jordanians about possibly getting Saddam Hussein to go into exile, which would have been an attractive option, it seems to me. The intelligence was that there was no nuclear and he didn't have the means, but if he could have done it, he would, so there was no immediate threat there. And the evidence on the chemical and biological was people thought there were laboratories and people working. There was doubts even if it was weaponized. So surely, if we'd gone more calmly and slowly, I would have liked Saddam Hussein to be sent to the International Court for crimes against humanity and crimes against peace, as we got Milosevic. I remember Anne Clwyd bringing that up in the House of Commons and Tony Blair saying he was looking at it, but it was never seriously looked at. So I am saying that we could have gone more slowly and carefully and not had a totally destabilised and angry Iraq into which came Al-Qaeda that wasn't there before, and that would have been safer for the world, and that Tony Blair's account of the need to act urgently somehow because of September the 11th, I think doesn't stack up to any scrutiny whatsoever. We've made Iraq more dangerous as well as causing enormous suffering and diminishing our reputation.
So you think that there were alternative ways, other than toppling Saddam Hussein, of preventing him from becoming a more serious threat?